Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Hello?
Hello,
Who are you?
Tawana Reynolds.
Tawana Reynolds?
Yes,
Okay, can you hold on? Let's see if I have
yes,
it. I do. We can get you started in just a second.
okay.
263. We are on the record calling file number 22-192163, Debt Holdings LLC versus Tawana Reynolds, date and time for pretrial, your appearances.
Morning, Your Honor. Hamdi Sob on behalf of Debt Holdings, PA 2080.
And what is your name, ma'am?
Tawana Reynolds.
All right, this is our first pretrial in this matter. Mr. Soul, what is your case about?
Your Honor, this is a case that is a breach of contract case. The contract, a residential, not a residential, commercial lease agreement. And the breach, the non-payment of the rental obligation. The defendant is a guarantor to
To the contract.
yeah, to the contract, and so the LLC that was registered was also on the lease agreement. She was the guarantor, being that she guaranteed the rental obligations, and now there's a past due balance of $12,037.53.
Okay. Ms. Reynolds, is it your intention to represent yourself in this matter?
Yes,
You have an absolute constitutional right to do that. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. When you represent yourself, as is your constitutional rights, the same rules that bind that lawyer are going to be binding on you. Do you understand that?
yes,
Okay, what I'm going to do is I'm going to open your written discovery and I'll give you a return date. The next day with me will be Monday, December 12th at 10 o'clock. Does that work for everybody?
It was for us, Your Honor. I didn't receive a copy of the defendant's answer. If she can forward that to our office, I'd really appreciate it.
All right, one thing, ma'am, I have to tell you, if you elect to represent yourself, anything you send to the court, you must send a copy to the other side. Do you understand that?
yes.
So you can't have one copy of anything. Anything you send to the court, you must send to the other side. Your written discovery is now open. We will see you December 12th at 10 o'clock. Thank you both for coming in. We're off the record.
Thank you.
Hello? Mr. Hall, good morning.
Good morning, Your Honor. How are you?
I'm great. How are you today?
I'm feeling just fine. A little concerned about this cold air coming in, dictating that winter's around the corner. But other than that, I'm fine.
Mentioning you're not unfamiliar with it.
Yeah.
I don't have your opponent as of yet. Just wanted to
Nope.
let you know I knew you were here.
Okay, thank you.
Put you back in the waiting room.
All right.
Ms. Rudowski,
Good morning.
I don't know who this person is. I don't see Ms. Zagagoras. Maybe this person is there for them. Let's see. Hello? Hello? Valtier Tompkins? Sorry, I'm not getting a response from this person.
Okay.
You guys hear me?
Who are you?
Voltaire Tompkins.
Why are you here?
I don't supposed to be here.
Why, do you have a case here, sir?
Yes, sir. My lawyer sent me your Zoom and told
What
me
is
I
your
had
name?
Voltaire Tompkins.
What is the case number, sir?
Let me go back. I was just looking at this.
Upper right-hand corner.
I don't have the paperwork with me. I was looking on his email he sent me.
What's the name of the case? Are you defendant or the plaintiff?
I'm the defender.
Are you being sued? Who is suing?
No,
What kind of case do you have, sir?
CPL case.
Sir, you're in the wrong place. You have a criminal case, correct?
Yes, sir.
Sir, this is a civil courtroom. You're in the wrong courtroom.
Wow. So how do I find out? Where do I go, sir?
Go back to your lawyer and ask him to send you the correct Zoom number.
Okay, and if I can't get a hold of him, is it a number I can call?
You can check the court's website, sir.
Court website, and what do I type in?
Look up the court's docket and look up your name. It'll tell you what courtroom you belong in.
All right.
Thank you, sir. I don't have an opponent for you.
Okay.
Back to the waiting room you go.
All right. Thank you.
Good morning.
Good morning.
Your opponent texted the court, indicated he'll be a few minutes late. So as soon as he gets here, we'll get you started. I'll put you back in the waiting room, ma'am.
Okay.
Let's come in here. Mr. Russo. All right, we are on the record. This is file number 22-179641, Credit Acceptance Corporation versus Megan King. Date and time for motion for summary disposition filed on behalf of the plaintiff, your respective appearances.
Judge, may it please the court, my name is Attorney Richard Bruce, my bar number 35222. I'm the attorney of record for the Credit Acceptance Company, and I am the moving party in today's motion for a summary disposition.
And what is your name, ma'am?
Megan King.
Ms. King, did you file an answer to the motion for summary disposition?
Yes, I called credit acceptance and took a plea constance I can't think about what it's called, but to pay $2,500 and some odd dollars by January 16th.
Judge, I can answer that. I sent her a written settlement agreement. She's never signed it and returned it to me. And I just asked my secretary, did she send it back to me as of the moment? No.
I didn't, when I called to make the payment plan, I didn't know that I had to sign anything. They just told me they was
My
going to send
office,
me.
my office sent a settlement agreement, what I call a SOSA, and I sent a letter asking to do it. This is the way it is. So Judge,
They
I'm prepared to go forward
they
on my.
Excuse
said
me,
when I-
excuse me. One of the things we're going to do is we're going to talk one at a time. So, Ms. King, you did not file an answer to the motion for summary disposition. Is that correct?
What? No, sir. When we had the last court date, you said that we settle this. I called the same day to get a settlement, and I called and I thought that I could settle with that. They sent me a paperwork over stating that I could settle for $2,000 and some odd dollars for January 16th. So I thought that that was good. And when we come to court, then that's when we can find out that that was correct. But I didn't know I had to sign something because they didn't send me nothing in the mail.
Okay. Mr. Rusen, your motion for summary disposition.
Thank you, Judge. My motion speaks for itself. There is a car. The car had a payment schedule. Payments were made. Payment default occurred. Car was repossessed. Car was sold. This case is on the deficiency balance for the amount of the complaint, which is $12,920.98. My motion speaks for itself in the sense that you granted discovery. I sent defendant written discovery, which required answers in writing, which consisted of requests for admissions, interrogatories, and a production of document requests. And there was no answer to that. I filed this motion bringing the case to the court's docket on September 12th, 2022. Now, I can tell you that an email was sent to from my office to defendant October 18th. It had a cover letter. It says, "Good afternoon, Ms. King. Please see the attached stipulation of order letter that you should sign and send back to me. If you have any questions, call me between 9 a.m. and 5 p.m. at Monday through Friday." I've never received a signed copy back. Therefore, I ask for judgment in the amount of the complaint of $12,920.98, statutory costs of filing of summons and service of summons, and a $20 motion fee that total $127.29, a statutory $75 attorney fee. I ask for judgment today in the amount of $13,123.27. On that, I rest.
Could I say something, Judge?
Yes, ma'am, you may.
Yes, when we went to court on the last time, he said for me to call the office to settle. That's what I did. I called the office the same day to make a settlement, and the lady got on the phone and she said, "Okay, this is going to be your settlement payment." She said, "I'm going to send you a paperwork over in an email letting me know how much I was supposed to pay." I said, "Okay." That's what I thought that I was supposed to do, and then come to court, and then we come and you say, "Okay, we selling this for this amount. I didn't know I had to turn anything in and sign it because it was on the email. If I thought it didn't send it to me in a paper mail to sign or send back anything. All it said was the paper in the email was saying that I settled for $2,500 and some odd dollars. So I didn't know I had to send anything back and sign it because I called in to make the payment plan.
All right. If you folks want to work something out outside of court, that's between the two of you. But the letter that Mr. Rusin described said that you needed to sign it. You acknowledge that you didn't. Further.
But
it's
I didn't know that
Ma'am, I'm talking now. It is also uncontroverted that this motion for summary disposition was filed more than 60 days ago, and you have not filed an answer. Under Michigan Court Rule 2.116G4, when a motion for summary disposition claiming there is no genuine issue of material fact is filed, a party opposing that motion may not rely upon their mere allegations or pleadings, but must, by affidavits or otherwise provided in the rule, set forth specific facts showing there is a genuine issue for trial. If the party fails to do so, the judgment, if appropriate, shall be entered against him or her. In this case, in addition to failing to file an answer to the motion for summary disposition, the discovery in this case also included, among other things, requests for admissions. Under the court rule, requests for admissions, which apparently were unanswered, are deemed to be admitted unless responded to as provided in the Michigan Court Rule. And that those admissions are deemed to be conclusive. I'm looking at the request for admissions, admit that this is a retail contract, admit that the contract contains your signature, it was assigned to the defendant, and in number 5, admit you defaulted under the terms and conditions. Court is going to be compelled, ma'am.
Yes, Your Honor, but
Excuse me, ma'am, don't interrupt me.
I'm sorry.
The motion for summary disposition under MCR 2.116C10 is granted. Mr. Rusin, you may submit your judgment. If you folks want to work something out short of that, by way of agreement, I certainly have no objection to that. But ma'am, you chose to represent yourself, and for whatever reason, you chose not to follow the court rule in regard to the motion for summary disposition. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. We're off the record.
Thank you, Judge.
Yes, Your Honor. I
Ma'am,
don't,
you can appeal my decision.
but what is the decision? Honestly, I don't even understand
I
what's going
granted-
on.
I granted the motion for summary disposition as prayed for by Mr. Rusin in his motion. You didn't respond to it.
I
Thank you.
thought
You did not respond. You fucking great. All right, we're gonna have to go forward. 11:34. Please. We are back on the record, calling file number 22-187868, Benjamin Bernuti versus Vincent Cooper. We were last together on this file on October 25, 2022. On that date, the court granted the plaintiff's unopposed motion to reinstate the case. Defendant did not appear, filed no responsive pleadings. That unopposed motion was therefore granted. On that same day, October 25th, 2022, we sent out notice of today's pretrial, November 25th at 10 o'clock. It's now after 10:30. Could I have your appearance, sir?
Elliot Hall appearing on behalf of the plaintiff Benjamin Bernuti.
Your bar number, Mr. Hall.
P14546.
Mr. Hall, the defendant has failed to appear. No good cause of that failure having been shown. The default, the defendant is hereby entered. Look forward, sir, to your motion for default judgment.
Thank you, Your Honor.
Thank you, sir. Have a great day. As
You
always.
too.
Honor
Thank
to-
you. All right, thank you.
Bye-bye. We are on the record calling file number 22-192906. This file is entitled Ford Motor Credit versus Caroline Simmons. This is the first pretrial scheduled in this matter. By a notice dated October 24th, 2022, this matter set for hearing today, November 15th at 10 o'clock. It's now after 10:30. Could I have your appearance, please?
Good morning, Your Honor. Robin Stradowski on behalf of Ford Motor Credit Company, P number 71195.
The record should reflect that the notice of today's hearing was sent to counsel for both sides at the address used by counsel on their responsive pleadings. Counsel for defendant has failed to, no good cause of that failure having been shown. The default of defendants hereby entered. Looking forward, ma'am, to your motion for default judgment. Have a
Thank you,
nice-
Your Honor. Would you prefer us to file a motion or could we just submit the default judgment?
Court rule says you gotta file the motion.
Okay, we have, all right, we will do that.
Thank you.
Thank you.
Be safe. Bye-bye.
Thanks, you too.
We're off the record.
Wonderful music by Joe Hisaishi called Summer with Argentine guitar. And before that, William Herschel's superb Symphony Number 17 with the London Mozart Players, led by Matthias Barnett. In case you're just tuning in, you're listening to Tempo here on CBC Music, and I'm Julie Misrata. It's too loud. Turn it down. Those are words you probably hollered at your kids when the TV was turned up so high they couldn't hear you, or they had their music blasting full throttle in the basement. It's too loud, however, are words that Frédéric Chopin never heard. In fact, his audiences complained that he was too quiet. When Chopin was performing, he never produced enough sound on the piano to fill the entire hall because being quiet was Chopin's trademark. In a time when loud composers like Liszt and Berlioz were dominating the scene with music that's in their face, Chopin's compositions were intimate, personal, and quiet, and people still went wild for him, which just goes to show you that genius doesn't have to make a big news to get noticed. exquisite and food. We just took the break down Machetsky with music by Frédéric Chopin. Chopin's Nocturne number 19. I'm Julie Mizrawa, and you're listening to Tempo on CBC Music. If you're just getting to your breakfast, maybe nibbling on some toast and slicing a grapefruit, or you're having a granola bar as a mid-morning snack, well, have you ever wondered what they used to eat? You know, those big-time genius composers of days gone by. Like, for example, what did Mozart like to eat? Well, for starters, what was there to eat? When Mozart was alive, some of the everyday dishes that Viennese folks were cooking up at the time were things like tripe soup, braised pigeon with chestnuts, and almond casserole. One of Mozart's favorite meals consisted of liver dumplings and sauerkraut, and after dinner, some fruit and wine. In the morning, Mozart liked to drink hot chocolate and munch on bread rolls for breakfast. Here for you now is a complete performance of Wolfgang Amadeus Mozart's Symphony Number 31, Symphony Nova Scotia, by Georg Tintner. that was vibrant. You just heard a complete performance of Mozart Symphony Number 39, the Paris Symphony, the Symphony Nova Scotia, by Georg Tippner. Remember that any time you want to fill your space with classical music, you can have it all by going to cbc.ca/listen, where you will find nearly 40 classical music playlists to choose from, including Tuna's Ravis Tempo. Again, you go to cbc.ca/listen, and it's FREE free. And you are indeed listening to Tempo here on CBC Music. That one more classical performances to look forward to. My name is
All right. See if we can get Ms. Moore connected on audio.
Are you all right, Judge?
I'm doing well, counsel. How about yourself?
You know, I'm hanging in there, trying to make a living.
That's it. I have Ms. Moore on video and she's connecting to audio, but
I see that.
doesn't seem to be collecting successfully.
Oh, maybe now. No, can't hear her. Says it's connecting to audio still on the other. It's like she has two screens or something.
Right.
I don't know why she has two. Ms. Moore, you might want to disconnect and reconnect.
I don't know if she can hear us.
I don't know if she can either.
Let me put this other one in the waiting room.
Okay. There we go.
We are on the record calling file 22192547. Forest Health Medical versus Shante Moore. Date and time for a motion. Motion seeking to change venue filed on behalf of the defendant. Your appearances.
For the record, Your Honor, Stuart Collis, P49530 on behalf of the plaintiff.
And what is your name, ma'am?
Shante Moore.
Ma'am, you filed a motion to change venue to the 14th District in Washtenaw County.
Yes, sir.
Please proceed with your motion, ma'am.
I'm normally out that way. Monday through Thursday, I'm helping my aunt. And it'll just be easier for me because right now, currently, I'm not working.
Now, this is a claim for medical services, correct?
Correct, Your Honor.
Yes.
Where were the medical services rendered?
In Washtenaw County, in Ypsilanti.
All right, Mr. Collins, what's your response here?
Your Honor, pursuant to MCL 600.1621, the appropriate venue is the place where a defendant resides, has a place of business, or conduct business. Ms. Moore clearly resides in Detroit. She gets her notices in Detroit. Consequently, this is the appropriate venue.
Ms. Moore, you live in Detroit?
Yes, I do live in Detroit, but currently I'm in Ypsi. I'm taking care of my aunt that lives out here.
All right, well, venue is proper in either location. But I guess my question is, we have to give the plaintiff's choice of venue deference unless there's some reason why it's improper. And all of our proceedings are probably going to be online. So it's not like you'll be driving into Detroit one way or the other. But I think if you are, so if are you still that same Detroit address? Is that where you are?
That's why I live Friday, Saturday, and Sunday.
Okay.
That's where I'm normally at.
All right. Then what I'm going to do, ma'am, is I'm going to have to deny your motion for change of venue because it's improper. But I mean, excuse me, venue is proper, but given the fact that we're doing it on Zoom, I don't see any prejudice to you. You'll be zooming, you can zoom in from anywhere. All right, so what we'll do is we'll set the matter for the next pretrial will be December 12th at 11 o'clock. Your written discovery is now open,
Your Honor, December 12th at
11
now-
o'clock.
11 o'clock. Now, I need to address one thing. Ms. Moore has not filed an answer, and I filed a default with the court, but I looked at the court ROA, but it doesn't seem to have received it. I know I mailed it out on 11/3. I assume that Your Honor is not going to enter said default since she's filed this motion
No,
and now is here, but she does need to file an answer.
yeah. Ms. Moore, make sure you file an answer 10 days before our next pretrial.
The other matter is that Ms. Moore had filed this motion, but she didn't serve me with a copy, so I'd like to remind everybody that copies do need to be sent to me as well.
Okay, because when I asked the court, they said they was gonna, when I did everything, they gave me mine and then they took the two, it was gonna send it out so that
No,
we'll
no,
both know.
That's the obligation of litigants, it's not the courts.
Okay.
All right, so we'll see you guys again December 12th at 11 o'clock. Your written discovery is open. The court will send out a order denying a motion for change of venue. Thank you.
Thank you
both.
very much, Your Honor. Good seeing you.
Let's be safe. Thank you all for coming in.
You just heard a police fight. There's all things that I'm over. Chicken with a beaking or lesson at the keyboard. And before that, music by David and the new maker. Hold on to the my soul. Spiritual buttons going. And pianist, Matthew Hagel. You're listening to Tempo. I'm Julie Israel. And this is CBC Music. If you were to spend 15 minutes a day reading the right books, a quantity that could fit on a 5-foot shelf, you could give yourself a liberal education. That's what the president of Harvard University said at the turn of the 20th century. His name was Charles W. Eliot. He was president of Harvard for 14 years. Now, with a publishing company called Wind of Eliot's idea, they asked him to fill that 5-foot shelf with books he considered to be essential reading. And that list is now known as book classics. It's online and gives you access to all the books for free if you want to check it out. Some of Charles W. Eliot's suggested readings are Dante's Divine Comedy, Homer's Odyssey, The Origin of Species, and Don Quixote. But in case you crack open a hard classic right now because they're in the car or working at their desk or working in the kitchen, here's the Toronto Symphony led by Peter Kingen with Nikolai Rimsky-Korsakov's The Amazon Suite, offering you symphonic stories from 1001 Arabian Nights, which is another modern classic on Charles W. Eliot's list.
We are on the record calling file 22-192366, Credit Acceptance Corporation versus Darren Anderson. By a notice dated October 28th, 2022, and sent to the parties on that day. This matter is set for hearing today, November 15th at 11 o'clock on the plaintiff's motion for change of venue. It's now 11:15. Could I have your appearance?
Good morning, Judge Robinson. Cezanne Barta, P65425 on behalf of the plaintiff.
Mr. Barter, did you receive any pleadings in response to your motion for change of venue?
I did not, Your Honor.
Sir, your motion.
Your Honor, we filed suit in your honorable court in the process of serving the defendant. We have an address in Southfield, Michigan, which would be the 46th District Court. So we were looking to change venue to that court at this time.
Your unopposed motion to change venue will be granted.
Thank you, Your Honor. Do you know if there's an order?
Let me take a look right here.
I'm assuming my staff probably put an order to change venue in there.
I believe so, but the problem is, yep, the order's fine. I'll use that.
Perfect.
Be safe, Mr. Barter.
You too. Have a great day.
Thank you. You too. We're off the record.